Welcome to Amber Book's 40 Minutes of Competence. I'm so glad you're here. So what we asked this week is, what are each of these labor laws and how and under what circumstances do they apply to an architecture firm? So we have the FLSA, I-9, HIPAA, ERISA, the Equal Pay Act, OSHA, Workers' Comp, Minimum Wage, COBRA, ADEA, ADA, Civil Rights Act, FMLA, Obamacare, EEO reporting, and affirmative action. So before we do that, we're going to break into groups and we're going to answer the following. Under which circumstance can you fire someone? And you can select more than one. You don't like the color of their shoelaces. They express political speech at work in support of a candidate. You suspect they've been stealing from you, but you can't prove it beyond reasonable doubt and are nowhere near certain. So which, or if any, and you can pick more than one, which of these can you be fired for, or can someone fire you for, or can you fire someone for? All right, so the question was, under what circumstances can you fire someone? And you could select more than one. So can you fire someone if you don't like the color of their shoelaces? Absolutely, you can. You can fire someone for no reason at all. We'll get into that. Can you fire someone because they expressed political speech at work, like support of a candidate? Absolutely, you can fire someone because they express political speech at work. If, for instance, you own Uber and you don't want your drivers talking politics with the people that get in the car because you're going to offend a third of the people who get in the car, no matter which position you take, you can say you can't talk about politics in the car. That's actually okay. The First Amendment that protects free speech is in there to protect free speech from government interference. It does not protect free speech from interference from your boss. It doesn't mean you can't be fired. It means the government can't put you in jail for saying something that's not popular or for saying something that runs counter to what the government in place at that moment would like you to say. What if you suspect they've been stealing, but you can't prove it beyond a reasonable doubt, and you're nowhere near certain? Absolutely, you can fire someone for that reason. In fact, you can fire someone for no reason at all. You just can't fire someone for a certain set of reasons. We'll get into those in a little bit. But it varies wildly state to state. But and of course, it's different if your employer happens to be the federal government. Then the rules are a little bit different about political speech and free speech. But if you suspect someone's been stealing from you, but you're just not sure, you can still absolutely fire them, because the innocent until proven guilty, again, that's to prevent the government from putting us in jail unless they're really sure we did it. But your boss can fire you even if she's just pretty sure that you did it. All right, so let's go on. All right, so generally these break into three categories, and these aren't the exact correct numbers. Sometimes, depending on which one it is, it varies. But generally, from 0 to 15 people, these guys apply, and from 16 to 50 employees, this applies, and for bigger companies, these apply. Now, for the bigger companies, the earlier ones apply also. So the Fair Labor Standards Act applies for all of them, and COBRA applies not just for medium-sized, but also for large companies and so forth. It's kind of backward looking in that way. All right, so what does it actually mean? Let's go through each of these finally, because I'm sure you're dying to know. All right, so the FLSA is the Fair Labor Standards Act. It sets minimum wage, it sets requirement for overtime pay, it's what established labor laws. I'm sure you know some of the history of minimum wage. It's a 1910s era kind of idea out of Massachusetts. It spread to the country during the Great Depression. FDR encouraged big companies and states to set minimum wages, but the Supreme Court struck that down. Even state laws said, states can't set minimum wages. And FDR tried to pack the courts. He tried to add extra judges to the courts. He wasn't able to do that, but under pressure that he may be able to do that, the Supreme Court started allowing some of FDR's signature legislation to slip through, and one of them was the minimum wage. Now, The minimum wage today is $7.25. Hasn't gone up in quite a while. In fact, the minimum wage when I was working minimum wage in the late 80s, if that was today, that would be over $10 an hour. And individual states, of course, now have many of them have minimum wages that are much higher. Most notably, Washington State, at least Seattle. Cities also have their own minimum wage. Seattle has now a $15 an hour minimum wage. It's now a living wage. Now, one of the ways we, of course, all as consumers get around the minimum wage and having to pay for things that are paid for by minimum wage is we purchase things that are manufactured overseas. So that's kind of a sad kind of byproduct or unintended consequence of the minimum wage. All right, now overtime pay has actually changed a lot lately. They're always kind of arguing whether so managers don't have to be paid overtime, and actually maybe if your firm pays overtime, maybe is generous with overtime, maybe you should let us know that your firm is generous with overtime pay, so that other people who are maybe looking for jobs can know which firms to go to. But you can put that on the chat. But overtime pay, professionals don't necessarily get overtime pay. Managers don't necessarily get overtime pay. So companies have been kind of playing with who's a manager and who's considered a professional, so they don't have to pay overtime they don't have to pay overtime. And this kind of continues to go back and forth. And of course, child labor laws, not as relevant anymore because we all kind of agreed not to hire children. So I think it's probably been, in fact, I know it's certainly been a benefit to society. All right, so that's the Fair Labor Standards Act. You have to pay overtime. Sometimes you have to pay minimum wage, and you can't hire children. An I-9 is a form that allows an employer to ask you and sometimes require proof that you are legally permitted to work in the US. So you have eligibility verification, that's the I-9. HIPAA is a law that was passed. So for, again, all these should be pretty obvious, self-apparent how they apply to architecture firms. But the I-9, if you were an architecture firm, you would be, and you were hiring employees, you would be required to hand those employees an I-9, and they would have to certify or affirm that they were legally permitted to work here in the U.S. And so what happened was, what ERISA says is it says that it stands for the Employee Retirement Income Security Act. And what it does is it says that people who handle your retirement funds for a company in your architecture firm, they have to act as fiduciaries. Now we'll talk in a little bit about what fiduciaries are, because that comes into play also on this exam. What's a fiduciary and whether an architect is a fiduciary. But what happened was in the 70s, both unions were sometimes some of the money that was put away for pensions and unions was going to risky investments, or maybe was being funneled off. And around the same time, the Studebaker car company went bust. And when it went bust, the workers were devastated to learn that the company had dipped into the retirement money they had put aside for employee retirement. In their effort to stay solvent near the end of the company's life, they had dipped into that money, and there was no money left for the pensions that the employees had put into and thought that they were given, thought they were going to get. It just wasn't there anymore. And so what Congress did is they passed ERISA, which stands for, again, the Employee Retirement Income Security Act. And what ERISA did is it said, look, anyone who runs a retirement plan or a healthcare plan or a life insurance plan on behalf of a company has to be a fiduciary. Now, what's a fiduciary? A fiduciary is someone who has to act by law in the best interest of his or her client. So or at least you should know, that when you go to a lawyer, for instance, that if the lawyer is telling you to do something, the lawyer believes it's in your best interest. It's not necessarily in the lawyer's best interest. Now, of course, it's difficult to prove, but the lawyer has to act in your best interest. Your accountant can't steer you to an accounting product because she makes money on it. The accountant has to steer you to a product because it's the best product for you. Now, we know that if we go to a used car salesman, that person is not our fiduciary. If it says used car salesman on their business card, and then they say to us, you know, you really should buy this car, this particular car, we know that he may be selling us that car because he makes more money if he sells us that particular car. Maybe there's a bonus to get rid of that car today. So we're aware of that. And on the other end, with a doctor, if a doctor tells us to do something, we have every reason to believe he's acting as a fiduciary. So he's acting in our best interest. But there's a whole kind of scale in between. So go ahead and answer to yourself as I go through these. But is a stockbroker a fiduciary? Yes or no? Just go ahead and answer to yourself. No, a stockbroker is not a fiduciary. So if you're a stockbroker, you can sell someone, you can push a particular equity specifically because you make a higher commission on that equity. That is legal. What about a financial advisor? No, a financial advisor, at least until recently, was not a fiduciary. Now, recently they tried to pass a law making financial advisors fiduciaries. They may be now, I'm not quite sure what happened to that law. A certified financial planner is a fiduciary. That's why you should definitely, if you're talking to a financial advisor, you want to ask them, are you a fiduciary? Are you acting in my best interest, or are you allowed to act in yours? So here's the big question. Is an architect a fiduciary? So think about it. Is an architect a fiduciary? If an owner hires an architect, can the owner expect legally that the architect has to steer the owner in the direction that that best benefits the client? Go ahead and think about that and answer, and really answer. Like, say to yourself, like, freak out the people in your room. Be like, yes or no, or whatever you want to say. All right, think about that. An owner is not a fiduciary. I'm sorry, an architect is not a fiduciary. It's crazy, right? You would hope that an architect acting professionally would act in the owner's best interest, but the architect has to meet the standard of care, which is what another architect, the bar that an architect has to clear is to provide service equal to or approximately equal to what other architects practicing at that same time in that same locality are offering their clients. So an architect is not a fiduciary. An architect has a much lower kind of bar to clear, maybe in part because the AIA writes the contracts that that us architects get to use. All right. So because some of the money was disappearing from people's retirements, Congress stepped in the 70s and wrote a really kind of poorly written law that's kind of difficult for the courts to interpret, called ERISA, which requires that that people who are handling your retirement right now have to act in your best interest. They are not allowed to act in their best interest unless it also happens to be your best interest. The Equal Pay Act, it prohibits wage discrimination by gender. The Equal Pay Act prohibits wage discrimination by gender. My Uncle Jim, actually it's my wife's Uncle Jim, is a labor lawyer, or was before he retired. And I called him in advance of our discussion tonight, and he told me a story, actually his wife did, of how he sued Saks Fifth Avenue because they were paying men who were selling women's shoes significantly more money than they were paying women who sold women's shoes at Saks. So the Equal Pay Act requires that you pay people the same regardless of their gender. All right, OSHA. OSHA, you probably know, is the Occupational Safety and Health Act. It created another OSHA, which is the Occupational Safety and Health Administration. And OSHA protects employees from workplace injuries. Now, that is a huge issue on a construction site. So in that way, it is relevant to the architect. It's less of an issue, of course, in an architect's office. I think you're required to tell OSHA if you have a workplace death, and I think you're required to tell OSHA if you have any more than 3 workplace injuries from one incident. So even as an architecture firm, and of course as a construction site, there are all kinds of OSHA requirements about what you can do to water and what chemicals you can use, and you have to wear hard hats and safety vests and work and gloves and glasses and etc. So that's OSHA. Our next one, workers' compensation. Workers' compensation, and so that's basically an insurance that pretty much anyone with an employee is required to carry, and it gives those who are injured at work both wage replacement and medical treatment if necessary. So if you're injured at work, workers' compensation will pay for your wages, and it'll pay for your treatment. And then finally, for our small firm, minimum wage. And you guys again know what minimum wage is. We talked about it under the Fair Labor Standards Act. That's the least you have to pay your employees. All right. Now for the middle-sized employees, 16 to 50-ish, again, some of these might not be quite be, some might start at 20 or something like that, but generally these are for mid-size firms. And of course the mid-size firms have to comply with all these others as well. And for these mid-size firms, they have to provide COBRA. Now, what's COBRA? COBRA stands for something, I can't remember what, but it basically says that you lost your job and your job came with health insurance. Well, you're allowed to pay temporarily out of pocket to stay with your old health insurance while you look for new health insurance. So if you lost your job and you haven't found a new job yet and something horrible happens to you, you can use this as a bridge or as a stopgap to allow your insurance to run uninterrupted. Same thing if you divorced your spouse and you were on your spouse's health insurance, or if your spouse died and you were on your spouse's health insurance and now your spouse no longer works at that firm. And so you're allowed to have continuation of health coverage. All right, somebody wrote that it stands for Consolidated Omnibus Budget Reconciliation Act of 1985. So that's what COBRA stands for. All right, the ADEA. The ADEA is the Age Discrimination in Employment Act. It prohibits age discrimination. So you can't not hire, you can't say, you know what, I'm a technology company and young people are better at technology, so as a policy, I'm gonna only hire young people, I'm not gonna hire people who are old. You can't do that. But interestingly, ADEA only protects those who are 40 and older. It does not, you can say, I'm not gonna hire someone because they're too young, but once they're above 40, then you cannot say, I'm not gonna hire someone because they're too old. Now, why do they protect people who are too old, but not people who are too young? Well, of course, it's because people who are over 40 vote, and people who are younger than 40 generally don't. Believe me, if 18 to 23-year-olds voted quite a bit, if they voted at the same levels as people over 40, they would be protected as well. All right, the ADA, the Americans with Disabilities Act, of course, you know all about that one. That allows for folks who have trouble walking or folks with other disabilities. It allows them to be able to access many of the same things that able-bodied people can access. The Civil Rights Act protects workers against, okay, so these are the reasons you can't fire someone. It protects workers against discrimination on the basis of race, color, religion, gender, and national origin. So if you fire someone or treat someone poorly based on those reasons, not based on the color of their shoelaces, but based on the color of their skin, obviously that is illegal and that is not tolerated. Now, as of this year, as of 2020, this also includes sexual orientation. So the Supreme Court justices, in kind of a surprise move, voted to extend the gender part of the Civil Rights Act, the part that protects people for gender. It said, okay, well, wait a minute. That extends also to sexual orientation and trans Americans. All right, that sums up our mid-sized companies. They have to meet the requirements in those laws. And then for the bigger companies, have to meet all the earlier ones that we looked at. Plus, the bigger companies have to meet the FMLA, and that's a 1990s era, Clinton era law. It's a Family Medical Leave Act. And what that does is it allows employees to take unpaid leave, and it's unpaid leave that's job protected. So, and you can do that for medical reasons. So something like a birth, something like an illness, something like an adoption, something like military deployment. You can keep your job if you leave it, if you left it for kind of a good reason like that, or at least what I would consider a good reason. So that's the Family Medical Leave Act. But again, you see that does not apply to small companies. So my understanding is that for a small, and of course for any of these things, you need to consult a labor lawyer. I mean, I don't know if this is an architecture thing or a faculty thing. I suspect it's a faculty thing. 3 different times I have heard faculty members with supreme confidence and assurance assert something in a faculty meeting or in a faculty discussion about labor law that I was pretty sure was not true. And all 3 times I checked with our university lawyer, I said, a colleague of mine said this, is this true? And they said, no, that's not true. But the person thought it was true. They were sure it was true. So I will say that I think a lot of people who would never claim to really understand the law think that they understand labor law. And so I had one colleague who once told me that we were bringing a visiting, not a visiting, it was we were bringing people in to interview them, and the interview process for architecture faculty and faculty in general is a really lengthy process. It's like a 2.5-day, 3-day process sometimes. And so we were bringing in 3 people in a row, like 3 people in 6 or 7 days. And so I was scheduling each of those 3 candidates, faculty candidates, to maybe get a job here at Virginia Tech. I was scheduling them each with a different studio. I thought it would be a good idea for them to review a studio. So I wrote to all the studio, I was at the time the program chair, so I wrote to all the people who were running studio, all the studio faculty. And I said, hey, we have someone coming in who's going to be hired as studio faculty, and everyone here at Virginia Tech teaches studio. We only hire really people who are capable of teaching studio, even if they're teaching something else. And we said, and I said, okay, which faculty members want to take this on? You get a guest critic for free for an hour, and I will arrange the whole thing, and it'll be in this room, and all you have to do is show up in this room with a few students, and then you can tell us later on how that person did with the students. So I set that whole thing up, and then a colleague of mine said, no, that's not legal. It's not legal to have 3 different people. You have to give them the exact same environment. So I said, oh, really? Oh, that sounds horrible. Because I didn't want the same studio to have 3 classes in a row, have a guest critic and have to organize that. I wanted different classes to each have a little bit of influence from outside, since we were flying them in. So of course I checked with the university lawyer, and the university lawyer said, that's crazy. You can't give everyone the same experience. What if the restaurant's closed that you took them to? Or what if there's a snow, or what if there's or the flight's delayed? There's no way to do that. And it's not required anyway, certainly not by any law, nor is it required by any university policy. So don't even get me started. So people think, I think, that they know more about labor law than people really do know about labor law. And even if you do know a lot about labor law, it varies wildly from state to state. And sometimes the state labor laws are much more stringent than federal laws. And I'm talking to you, California, but not just California, lots of states. And then different employees, like I work for a state government at Virginia Tech. And so because I work for a government, there are different laws still. And those, of course, who work for the federal government and so forth. All right, Obamacare, or the AMA, ACA, the Affordable Care Act. What that requires, it requires that large employers offer affordable healthcare insurance as an option for those working 30 or more hours per week. EEO reporting. So the EEO is the Equal Employment Opportunity, and the reporting, and the EEOC is the Equal Employment Opportunity Commission. And if you're a big company, actually that one I think is for 100 or more employees. In fact, I know it is. That one is for 100 or more employees. And what it says is, if you're an employer that's of that size or larger, you need to report hires by race and gender. And affirmative action, finally, is a requirement for large companies that employers have to both recruit and advance qualified minorities, women, veterans, and persons with disabilities. All right, that concludes that. Let's go on to next week. What are we going to do next week? Next week, we're going to talk about the terms that are associated with heating, cooling, HVAC. So you have to tell me what each of these, you have to be able to tell yourself what each of these does. A condenser, a compressor, an evaporator, an air-to-air system, an air-to-water system, a water-to-air system, a water-to-water system, a split system, a mini-split system, a swamp cooler, an evaporative cool tower, which is different than a cooling tower, a chiller, an air handling unit, a fan coil unit, what direct expansion is, variable versus constant cooling coil, variable versus constant ducted airspeed, variable versus constant fan or pump, a geothermal system, and finally, chilled beams. So next week will probably be a little bit of a long one as we go through these those concepts. And if in the meantime, if you need a refresher on those, go ahead to Amber Book's YouTube channel. So if you just go to YouTube and type in Amber Book, and there are 3 parts for how does air conditioning work. And you'll probably want to watch those because especially if you're not comfortable with this stuff, it'll be helpful anyway. It's like 3 videos and each one's, I don't know, between 5 and 10 minutes long, I think. And so you'll want to watch those 3 so that you're a little bit more familiar with things as I talk about them, because frankly, I started animating. That was actually the first videos I think I animated, because usually what you see in an air conditioning book is they say stage 1, and they have the compressor and they have the condenser and they have the expansion valve and the evaporator, and they say stage 1, it's under high pressure, and this is under low, and this is, and they show that things are moving around this way. And it's just so much better to see it move along the time domain. So understanding air conditioning is an important part or I should say, understanding air conditioning is really fertile for exploration with animation. All right, and then going back to last week and some of the questions that were on the chat last week, when I was going over all of the things that are required, they're not required, all the things that are useful to handle noise control in an apartment. And those of you who were here last week, someone wrote, can't afford all that fancy stuff in New York City. My bedroom wall backs up to the neighbor's kitchen. We hear their cabinet doors closing and their blender running. And then someone wrote, Professor Ermann, would you please address Gerald's comment about the inefficiency and unaffordability of some of the prescribed methods you listed in the acoustic solution this week or next week? So yeah, I mean, some of the things are very expensive. Most of them are not, if they're treated early. So it's really expensive to have 2 doors, but if you put noisy spaces far away from quiet spaces, you won't need to have multiple doors or very expensive acoustical doors. If you don't locate your building next to the train track, you won't have to worry about expensive windows that keep the noise out. So things like site selection and space planning and kind of orienting something on the site and forming the building. I mean, which side of the building is going to face the road? Is it going to be the side with the busy highway? Is it going to be the side with the buffer zone of the utility room or the garage? Or is it going to be the side with the bedrooms? And so these are free architectural decisions early on. They're only expensive later on. And then of course, some of the things are very expensive. So having double walls or having a geothermal system so you don't have to hear the outdoor equipment, or certainly many of the the solutions for impact noise from footfall above, those are extremely expensive in wood construction and concrete, but especially for wood. And so, yeah, sometimes just having quality costs money. And that's just the way it is. All right. And then someone put, I love hearing my neighbor from above playing with his dog all day. And someone said, haha, carpet sucks, because I kept saying carpet sucks, because carpet sucks. Never gets clean. It's made from petroleum. It's ugly always. And someone said yes, and someone else said yes. I mean, what a great time to be an architect, because the population, the community, the world at large actually agrees with us. You know, people are shopping Target instead of Walmart. People are shopping All Modern. People like design. And, you know, it started 15 or 20 years ago, and it still goes on. I keep waiting for the pendulum to swing the other way, but people seem, the culture seems to appreciate design in a way now that it did not in some decades past. They hate carpet now in the way they did not in some decades past. Thank you for that. I'm not sure who, what deity brought us that, but thank you to that deity. And they seem kind of interested in architecture and aware of it. So it is a good time. Maybe it's HGTV we have to thank, but I don't think so, because a lot of their stuff sucks. I keep wanting to get into HGTV, but I just don't like it that much. All right. And then later someone said, Michael has special access to everything. And then someone wrote, it's true, Michael called me back. And so I just thought this is another good time. I've done it in other 40 minutes of competence, but my phone number is 540-558-8279. And then he went on to write, failed an exam, he encouraged me to immediately take another, and I passed. And so, I mean, I'm happy to talk to you about failing exams and whether you should take it again, based on how badly you failed, but I'm happy to talk to you about anything. I can talk to you about professional competence. I can talk to you about technical competence. I'm not a very good musician. I can't talk to you about that, which is my great shame as an acoustician. But anyhow, all right. Then someone asked, and this was asked in over the speech portion of the session as well. What does NS, S1, and SM stand for in code tables? And so they're always both in the code table and also in the exam. Those are at the bottom. So you'll have NS or S1 or SM in the code table, and then at the bottom it'll say NS is buildings not equipped throughout with, so it's no sprinkler. NS is no sprinkler. And S1 is a buildings of a maximum 1 story above grade plane, equipped throughout with a sprinkler system. Okay, so that S1 is a 1-story building that is sprinklered. SM are 2 or more stories above grade, equipped with an automatic sprinkler system in accordance with 903.3.1. S13R are buildings equipped throughout with an automatic sprinkler installed in accordance with 903.1.2. So that's what that one is. Anyhow, it's the same with the others: UL unlimited, NP not permitted, NS building, and so forth. S13R are again buildings equipped throughout with an automatic sprinkler system, a certain kind of sprinkler system that meets a certain code minimum performance. And finally, I am not working in an office and need to learn how to read details better. What is a good source? Let me come over here to my bookshelf. The Architect Studio Companion is a pretty good source. Yeah, that's a pretty good source. It's one of those things, just like code. The more you do it, it becomes really easy. It's like software, you know. You don't understand the software, and then you think it's really hard, and then you use it a little bit, and then you can't believe anyone else thinks it's hard, and you're impatient with others when they ask you questions. Yeah, I would say that's a good place to start. I don't know, maybe some of you guys, Architecture Graphic Standards is a good one. That's someone that Jennifer wrote that on the chat, but that's a really long one. But you could start there. You could, let's see. All right, you ready? A statute of repose is a hard deadline on the time window in which an owner can sue the architect. So you can imagine a statute of repose of 10 years from substantial completion. And let's say you found a leaky roof slowly rots the rafters, and the leak started before the 10-year mark, but the discovery of the rotten rafters occurred after the 10-year window. In a statute of repose situation, the owner waives the right to take the architect to court. So the statute of repose, if it doesn't matter when it started happening, it matters in terms of whether it's covered or not in a warranty. It matters when you found it. In a statute of limitations, it's a more flexible deadline. The courts can interpret that differently. So for that one, we can imagine instead we have, let's say we have a 10-year statute of limitations from substantial completion. Now the judge has the flexibility to rule that because the leak started before the time limit, the suit can proceed even though the discovery of the rotten wood occurred after the 10-year time limit. So most states, so even if it, so if the owner can prove that the leak started before 10 years, but they only discovered the rotten wood after, they may still be able to sue.
Wait, but the discovery happened before 10 years.
No, the discovery happened after. In statute of
leaking?
limitations, the rotten wood. So no one ever saw the leak, we just saw the rotten wood. It was this tiny little leak that just chipped away at the wood. So most states have both limitations of statutes of limitations and statutes of repose. Automatically.
Sorry.
So most states have both of those automatically written into law. And so, there may, for instance, be a 6-year statute of limitations, which means that the leak arrived within 6 years, but rotten wood not discovered until 7 years, so it's okay to sue. And they may have that with a 9-year statute of repose, which means a hard deadline after 9 years. So even if the leak occurred within 6 years, after 9, if it's not discovered after 9, there's no liability. And some states, and I'm talking to you, New York and Vermont, have no limit on the length of time that the architect is exposed to a lawsuit. So it's going to vary state by state. But a statute of repose means it doesn't matter when the problem happened, it matters when you brought it to my attention. A statute of limitations, it may matter if it's interpreted that way. It may matter. It may matter when it happened, when the thing caused it, not later on when you actually found the rotten wood. Now, most states respect what they call the private law of the contract. So if the contract says that the architect and the owner agree on a different deadline, different statute of limitation or statute of repose, the contract deadline will supersede the state's default time windows. The AIA agreement spells out that the statute of repose, the stopwatch for litigation, begins at substantial completion and extends to either. So from the AIA kind of standard agreement, that the AIA is going to use a statute of repose, which again means after that point, it doesn't matter when the problem started, it's when you discovered it. And you can't sue after you discover it. And it begins at substantial completion and extends to either the state's default statute of repose or 10 years, whichever is shorter. So this 10 years, or if the state says it's 6 years, then it's 6 years. And as you might imagine, the architecture profession generally advocates for the certainty associated with statutes of repose, which means it's about when you find the rotten wood. It's not about when you can guess when the leak started. That begin upon substantial completion. While the owners often advocate, the architecture profession wants the certainty of the statute of repose. The owners often advocate for the flexibility of statutes of limitations, or they may write their own contracts where the clock begins ticking upon the discovery of the defect rather than its substantial completion. So keep this in mind, right? I think it was Luciana who asked this. So if you're an architect and you're sitting across the table from an owner, a developer, and the developer gives you a contract and starts negotiating, who do you think is going to win that negotiation? The architect or the developer? I mean, they will chew you up for sport. And so what they will do is they'll say, okay, we're going to just use our contract. It's kind of like the AIA. See, it's a 10-year thing, but they may say it's 10 years from when the discovery of the leak or the discovery of the rotten wood, not 10 years from the substantial completion. And you may not catch that because you're not that savvy, because it's not your fault. No one's that savvy. So, yeah. So if the owner or third party in that situation, can theoretically sue forever because they may find a leak at some later time and have 10 years from when they find the leak. So all kinds of questions come up. When can the architect cease carrying liability insurance after retirement? Or if you're a firm and you want to purchase another firm, how do you not, and that firm signed contracts with the developer that says that they're liable forever? How are you supposed to value that risk? You don't really understand what that client, if that client's likely to sue or not. So that's the skinny on statute of repose and statute of limitation.
This is awesome. Thank you. Can I
You're
just
welcome.
clarify? Is limitation shorter?
No, they can each be any amount of years, but
Okay.
limitation is squishier and it's open to more interpretation.
I
as
thought
to
it's
when
3 to 6 years. No, it doesn't say. It's not
it,
necessarily true.
it depends on the state and it depends on the contract. But the contract says 10 years or whatever the state has, whichever is shorter. The standard contract says that. But limitations is not about when the owner, or not about when the owner says, oh, limitations. Limitations allows the owner to say, even though I just discovered it now, I think this is because it was a problem from a long time ago that led to this. Whereas repose says, after this date, you can't sue. It doesn't matter what you say. If there's no problem that you can show before this date, you can't sue. So repose is a hard deadline, and limitations allows for a lot more interpretation of what really caused this problem and when did that problem actually begin.
Okay, sorry, Mike. I'm a little confused. You said hard deadline, but you also mentioned if the rotten wood was found after 10 years, they can still be sued, right?
Let's say it was 10 years. In the statute of limitations, if the rotten wood is discovered after 10 years and the statute of limitations was 10 years.
If repose is 10 years and you find
each one has its own number of years. Oh, your question is, okay, ask your question again. I didn't mean to bark at you. Go ahead and repeat your question.
No, you said the statute of limitation could happen even though the repose is already after 10 years, let's say, because it happened during the 10 years, even though the problem was found after.
Okay, so you can have a situation where the statute of limitation is some number of years and the statute of repose is a different number of years on the same contract or in the same state. So you can say that there's a statute of limitations, say, of 7 years and a statute of repose of 9 years, which means that it means that you, the owner, have to prove that that even if you discovered it in year 8, you have to prove that that the real problem started, even though you didn't discover it in year 8, that the real problem started in year 7 or earlier, and you can still sue. But if there's a statute of limitations, if you have a situation where you have a statute of limitations of 7 years and a statute of repose of 9, if you discover it in year 10, it doesn't matter if you can prove that it started in year 2.
Got you. Okay.
You're out of luck.
Thank you so much. Yes, yeah. I actually made a graphic with your explanation.
Send me yeah. Good. Okay.
Thank you.
I'll have to leave it at that. All right, guys. I will thank you. My sign off, of course. Good night. Get licensed.